Boa tarde a todos. Boa tarde a todos. Good afternoon, dear colleagues, dear students. I would like to thank you all, the participants present and those online. It is a pleasure to greet you at the International Symposium on Legal Research held at Lusófona University, Portugal, November 9, 2023. I begin by thanking the speakers of this important legal event, the professors from our university and the noble colleagues who came from Poland, Professors Tomás and Igor. It is an honor to welcome you in our university. Thank you very much for coming to Portugal. My thanks to Professors Paulo de Brito, João Proença Xavier, and Luisa Barrios. Thank you for accepting to be part of this international symposium. A very special greeting to all students at University of Lusófona, especially my undergraduate, master's, and doctoral students. Many came from far away to attend the event in person. Thank you for your effort. Likewise, I am grateful for the online attendance coming from other regions of Portugal, as well as Brazil and Spain. The International Symposium on Legal Research was designed to be a meeting of thinkers. In recent years, University Lusófona has received researchers from several countries, some closer to home like Spain, but we have also received researchers, for example, from Brazil, Italy, and now Poland. It is indeed an honor to host such prestigious researchers. We consider that holding this international symposium to be of great importance. Therefore, today our audience will have the opportunity to learn about different topics in the legal field from the perspective of someone who is researching the most relevant legal problems in depth. Thank you very much for your presence. Good symposium to everyone. Thank you. Now we started the Professor Tomás, our colleague, and your theme, your title is Participation of a Social Factor in Civil Proceedings in Poland and the Right to a Court. Professor Tomás is a judge of the Supreme Court of Poland and professor in Warsaw. It's an honor to come to Portugal. Thank you, Professor Tomás. Welcome. Yes. Leonardo. Vejo o rato aqui. Não? It doesn't work. No, it doesn't work. Okay. O rato. É um rato. Ela falou para segurar aqui. Segura esse aqui e mexe esse aqui. Olha. O rato não funciona. No working. Your computer. Why not? No worry. Yes. Went to the Zoom. Yes, yes. So can I give one close it? Yes, yes. Is that? Não tá? Consegue? Consegue mandar? How to go to the next page? Para mudar. Yeah? Ah, okay. Okay. Good afternoon, everyone. I want to thank you, Fabio, for invitation on this symposium. My name is Tomasz Szczęciło. I'm a judge of the Supreme Court of Poland, civil chamber, and professor in university. And I would like to present you the topic participation of a social factor in a civil proceeding and in Poland, of course, and the right to a court. I think this topic is very interesting because of participation of social factor. Let's start that we have three forms of citizen social factor participation in administration of justice.
Na administração da justiça,
Jury, através do júri,
através do júri,
Saxon Common Law System,
do sistema anglo-saxão, sistema de lei, common law,
lay judges as a member of the court,
dos juristas, dos membros dos tribunais,
courts, so
e o tribunal dos magistrados,
citizens who are in judges' seat. And operating in
situações não são juízes, mas
with minor neighborhood disputes. In Poland,
participam em disputas
the example of the continental legal system, system of euros was adopted. We can see that we have
we have three basic roles, functions of jurors' participation in administration of justice. Of course, general functions. The first is the social civic judge function. So the juror determines citizens' cases and on an equal, is very important, on an equal footing with the judge, having the same voting power. So his role is to present to the court the assessments and the views currently prevailing in social opinion, and to make appropriate and effective use of them in the exercise of this function. The second function is the civil social control over the apparatus of workshop of judges. So the participation of jurors is supposed to force judges to better prepare themselves to hear a case and hear it properly, and publicity of trial as well to conduct judicial proceedings thoroughly. So if the court should make a good decision. And the third function is a link between a court and society. So you shape the face of the judiciary in the public perception and influence public opinion. Popularize the law and the activities of the judiciary in the public perception, thus raising legal awareness and legal culture. In Poland, we have only one constitutional regulation on the issue in question, referring to statutory regulation, is the Article 182 of Polish Constitution. The participation of citizens in administration of justice shall be determined by law, by acts. So, what we can say about this regulation, the only constitutional regulation, it emphasizes that the construction of the provisions referred to is general, and the system legislator didn't have any conception of citizens' participation in administration of justice, and therefore we have some empty provision about this. The absence of even a general definition of scope of participation of social factor, or of its essence of or desire purpose, means that the constitutional principle of citizens' participation in the administration of justice hasn't been secured in any way. A result of this kind of regulation is the legislator has essentially unlimited freedom in shaping the participation of citizens in adjudication. The regulation of the even extent of participation of the social factor depends on view taken, namely whether it is in the positive or negative elements of the administration of justice. And it's therefore evident that the above principle isn't closely related to another constitutional principle, namely the right accord in Article 45 of Constitution of Poland. Because the right to a court doesn't include the participation of the social factor in justification. What we can say about jurors in court of general jurisdiction proceedings? of course, in civil cases. Jurors are non-professional judges who are intended to serve a judge who is the professional, his or her, it depends on man or woman, knowledge and life experience, ethical judgment, as well as a sense of justice, etc. A professional judge speaks in paragraphs, so he know the law, he know the acts, but non-professional judges, so jurors, in human voice. Jurors don't need to have a legal education or even university degree. Jurors have equal rights with judges, assessors when deciding the cases. It's very important that jurors are independent and subject only the Constitution of Poland and the laws, of course, when adjudicating. And composition in court of general jurisdiction proceedings with jurors always is the we have one judge and two jurors. Of course, judge always being a preceding judge. So it is very important that jurors can outvote the judge and de facto decide the content of the verdict because judgment verdict decision is made by majority vote. So it's Article 324 Code of Civil Procedure. In civil cases, jurors are in the count. We have one exception, but in general, in civil cases, jurors are in the county courts and the district courts only at the first instance. They aren't in courts of appeal. They are selected by councils of municipalities who are covered by the jurisdiction of these courts in the secret ballot, and juror can only be elected in one court. We will say about exception of this in Supreme Court. What cases, what kinds of cases social factor is used? We have in civil procedure we have three kinds of cases, two kinds in procedural, known as contentious proceeding, and one in non-procedural, known as non-contentious proceeding. How can you see that there are only in labor law cases, and family cases in procedural proceeding, and only one article in non-procedural proceeding. So there are it's about adoption cases in the first instance, of course. So only three kinds of cases. We can see that we have social factor. So what can we say about some conclusions about this? In civil proceeding, the participation on jurors in Poland, of course, is provided for a small number of cases. Only maybe 15 kinds of cases are included. Such of regulation, which contains a very narrow catalog of cases, gives rise to a view that it's a manifestation of the reduction of the participation of so-called social factor in administration of justice in favor of judicial professionalism. The purpose of leaving the above mentioned labor cases, as it's pointed out, they constitute about half of cases heard by a labor court in Poland, so it's rather high level. To be heard by EUROS was the intention to have them heard by persons with extensive professional and life experience, taking into account also social justice. But in family cases, where the welfare of minors and the family is paramount, and the law should therefore be applied extremely prudently, taking these factors into account. I talked about exception, and we have exception in the Supreme Court. So we have EUROS in proceedings in the Supreme Court. In 2018, the legislator introduced EUROS to the Supreme Court. So 5 years ago, it has been heavily criticized, primarily because legal review rather than fact finding is done in the Supreme Court. Supreme Court is court of law, not court of fact. But we have exceptions. This novelty has been justified by the need to enrich the jurisprudential panels with social sensitivity, as well as knowledge of life experience unrelated to the legal profession, like in common courts, like in courts of general jurisdiction, we can see. The participation of EUROS in the Supreme Court is relatively narrow because it applies only 2 categories of cases in 2 of 5 chambers of this court, only in extraordinary control at public affairs chamber and chamber of professional responsibility. So in cases extraordinary complaints and disciplinary proceedings. Only in these cases we have EUROS. Article 59 of the Supreme Court Act, unless otherwise stipulated by law in cases in Supreme Court where we have EUROS, of course, the Supreme Court should adjudicate with a panel of 2 Supreme Court judges and 1 Supreme Court Euro. As you remember, in common courts, in courts of general proceedings, we have 1 judge and 2 EUROS. So in the Supreme Court, we have difference because we have 2 judges, professional judges, judges of Supreme Court, and 1 EURO of the Supreme Court. But we have exceptions. We have 2 kinds of exceptions. Special rules for determination of bench compositing have been established for cases. And the first exception is from an extraordinary complaint concerning a decision made as a result of proceeding in course of which the decision was issued by the Supreme Court. So we have in this situation we have the Supreme Court composed of 5 Supreme Courts judges sitting in extraordinary control and public affairs chamber and 2 Supreme Court jurors. So this Article 94 of the Supreme Court Act. And the second exception is the cases of disciplinary judges of Supreme Court considered in the second instance. So we have 3 judges of the Supreme Court sitting in the chamber of professional responsibility and 2 jurors, of the Supreme Court. So this is Article 73 of the Supreme Court Act. This regulation is criticized, but we can see that the social factor in Supreme Courts concerned only specific cases, only in disciplinary cases, and only in cases with extraordinary complaints. What we can say about extraordinary complaint? This is regulated by Article 89 of the Supreme Court Act, and if it necessary to ensure compliance with the principle of democratic state of law, implementing the principles of social justice, an extraordinary complaint may be lodged against the final decision of a court of the general jurisdiction or military court ending the proceedings in a case, provided that this is new regulation. Legislator introduced it in 2018, so in the same time like yours. And we have 3 situations, but the ruling violates the principles of freedom and right of a human being and citizen set out in the Constitution of the Republic of Poland. So is general constitutional rules. The ruling grossly violates the law through in misinterpretation or misapplication, so it's rather for judges. And third situation, there is an obvious contradiction between significant findings of the court and the content of evidence collected in the case. So, of course, and the ruling can be reversed or amended by way of other extraordinary appeals. In civil cases, in practice, is brought, for example, when 2 conflicted court orders have been made to declare an inheritance. So, how can we see that especially in case of the last ground, there is explicit mention of possibility of reviewing the contest decision. So so in this situation, in this kind of cases, the Supreme Courts becomes a court of fact and evaluation of evidence, so like a court of appeal. So in these cases, Supreme Court is rather court of fact, not court of law. In disciplinary proceedings, as far as these kinds of proceedings are concerned, the court first established the facts of the alleged tort, which are significant for the decision, and then the court decided on the guilt or and the punishment. Thus, in disciplinary cases, the Supreme Court, sitting as a bench, conducts an evidentiary hearing, assesses the evidence gathered, for example, documents, witnesses, and then determines guilt and the degree of guilt, and consequently, of course, impose the penalty or acquit the accused. So, what we can say about, in general, about this regulation? First of all, the collegiality of the bench is the one of guarantees of the judicial independence, and impartiality gives the chance of reaching the correct decision. Everyone. It seems that collegiality of bench should provide to the better decision than decision of one judge. But the rule in a civil proceeding is, of course, in first instance, the one-person judge panel. So this regulation has a practical value because everything is decided by the judge, who is the professional lawyer, and the participation of the social factor in administration of justice in civil proceedings isn't extensive. So we can say that a principle arising from Article 182 of Polish Constitution was made really an exception by legislator in pro-civil proceedings. We can see on this solution, this regulation, from 2 points of view. If we are looking at such of a solution from the judge perspective, for example, like me, it justified that judge in the vast majority of cases doesn't have to consult his decisions with people who don't know the law to such extent as to be a real support to judge. But if you are looking from the perspective of society, it's questionable whether such of solution does it constitute an excessive limitation of social control of the judiciary. It's rightly argued in doctrine that the participation of jurors in many cases is merely formal, decorative, and causes additional unnecessary cost. Sometimes it's really true, because as practice shows, that the civil proceeding in vast majority of cases, of course, in general, legal and procedural issues are of primary importance, and these are undoubtedly the domain of the professional judges, and not to non-professional judges. Indeed, in criminal cases, we can see different points of view, but in civil cases, it's rather true that the law and procedural issues are more important than than in criminal cases. Of course, it's general conclusion, not about all cases, but in general, generally, it's really true. Thank you very much.
Thank you very much, Professor Tomás. Muito obrigado. Vou falar um pouquinho em português, porque vai falar agora o professor Paulo de Brito. Quero apresentar o professor Paulo de Brito em português, depois ele também pode fazer um pouquinho em inglês e português. O professor Paulo de Brito é professor associado aqui da Universidade de Lusófona, Professor of International Law, Direito Internacional, e grande amigo, grande colega já de muitos anos, antes mesmo de eu ser professor aqui na casa, já éramos colegas de vários projetos internacionais. Muito amavelmente aceitou o convite de participar do nosso simpósio internacional e vai falar sobre o tema International Law, the Lost in Metaphor, Reflections on the Current Wars. Né? Professor Paulo de Brito, tem a palavra, pode ficar aqui no lugar.
Também não agradeço muito o convite, o Fábio, grande dinamizador de muitos projetos a nível internacional, pelo gosto de conhecer já há alguns anos e agora com o gosto de ter como colega aqui na Universidade Lusófona. Ok, vou falar em inglês e parte também em português, mas what I'm going to talk about to you is something that we are facing today. And the question is, current wars that we're facing lead us to question international law. So, where is the normative character of international law? Is it really imperative? Is there really coactivity inherent to the concept of law? Or are we just talking about a metaphor? Are we just talking about some fantasy? Well, I had my PhD examiner, Professor Anthony Carty. He wrote in the last century, he wrote a book, a bestseller called The Decade of International Law. And it's very actual, even though this bestseller is from the last century, from late 80s. This is very current in a way that, are we facing a decline, a decade of international law? Is international law really law? What are we talking here about? That's something very actual, this reflection that I'm bringing to your attention. And not only to mention the war between Russia and Ukraine, but also we will have to mention Israel's recent response to the Hamas attacks that occurred on October the 7th. In an article published recently, November the 2nd, on New York Times, Amanda Tobe summarized and questioned this. If a wartime attack kills innocent people, how could it be legal? If the laws of war are so limited, what are they good for? Will anybody ever stand trial? What about the accusations of collective punishment? Oh, okay, these are her questions. But what we have to question here is, for the fact that we are violating international law every day, current wars, does it mean that then international law is not exactly law? That is the main question. and we can see, for instance, even when we're facing domestic law, when we're facing criminal law, sometimes criminals can get away without being punished. Sometimes we have something called statute of limitations. That means I can crime, 25, 30 years have passed and nothing happens to me. That is crime that remains unpunished. So because of that, we cannot speak about criminal law. And even when we're talking about constitutional law, if a head of government commits a crime and ultimately he or she is not punished because the constitutional mechanisms of this country do not allow that to happen, can we then question constitutional law as being really law? So these are only some questions for us to think about. So one thing is law having a validity of its own, being valid per se. Something else is law being effective or not exactly or not perfectly effective. And that this is my problem as well. So, that not being exactly effective. I mean, but that does not withdraw the fact that that can be and that is law. A professor that I also had said that one thing is validity of law, something else is effectiveness of law. And that's the question that we're facing nowadays. Okay, now, if we read the UN Charter, if we read Article 2, it is clear that it is mandatory that states should refrain to use force on the relationship with each other. It is also mandatory that states should engage in peaceful ways of solving their disputes. So then we could say use of force is illegal according to the UN Charter, right? Is it always illegal? So can we never use force in international relations? No, there are exceptions. And the exceptions are not when the use of force is justified by an organ of the United Nations itself, by the Security Council. It is also possible for a country to defend itself, and that is called in international law and using the UN Charter on Article 51, the right to self-defense. The right to self-defense is stated in Article 51 of the UN Charter, and that is this right of self-defense that Israel is claiming on its attack to Hamas and its attack on Gaza. The question is, the right to self-defense itself, is it an absolute right? If someone now, yesterday we had a very rainy day here in Porto, a student was about to hit me with an umbrella. I deserved that. But then I could hit back with an umbrella and say, well, I hit back in self-defense. But if instead of that, I pull a knife and I stick the knife into his stomach, well said, well, I did that in self-defense. Well, but then we could be facing something that is called excess of self-defense. I would have gone beyond what is a normal, a proportionate self-defense. And that is the question. The question is, can I use self-defense At random, can I violate international humanitarian law in the name of self-defense? Can I bomb an hospital? Can I bomb a refugee camp because I'm acting in self-defense? Well, that is the question that we're facing today. Okay. So, for many years, when we were talking in so-called international, well, let's have a look. Let's have a look on the role of the Security Council within the framework of the United Nations. Well, technically, the Security Council is the organ that is responsible for the use of force. The problem is that Security Council is composed of 15 members, of which 5 are permanent members. And these, the winners of the Second World War, that is United States, United Kingdom, France, China, and then the USSR, replaced by the Russian Federation, these 5 permanent members have the right to veto. So, 1 week ago, there was a General Assembly resolution asking for ceasefire and condemning the incursion in Gaza. The question is that why is that a resolution? Why that resolution came from the General Assembly? Well, it came from the General Assembly for the simple reason that it could never come out of the Security Council. Why? Because one of the permanent members could veto. Therefore, the General Assembly issued that resolution. And then the question is that resolution binding? Technically, no. Why? Because it comes from the General Assembly and not from the Security Council. So it means that we have a paralyzing effect by any of the permanent members exercising its right to veto. So let's leave us to an impasse, to a problem that, so we could ask, if this war is illegal, are there any mechanisms? Well, the mechanisms are very limited. So, okay, even when we talk, well, there is a warrant of arrest against a warrant of arrest issued against the president of the Russian Federation, Putin. There is a warrant of arrest by the International Criminal Court. What is the practical effect of this warrant of arrest? No, there is no practical effect. Recently, I remember, for instance, because it brought to my attention, President Lula said, well, if Putin comes to Brazil, to Garota de Copacabana, Garota de Ipanema, he will never be arrested. Well, that's bullshit. Why? Because Brazil is a country that abides by the rule of law. So it's up to the judges, it's up to the judiciary, Poder Judiciário brasileiro decidir. It's not up to the president. Brazil is not Venezuela. And a president elected in Brazil is not Hugo Chavez. So there is still rule of law and due process in Brazil. Therefore, the president can say whatever he wants. But the value of this wording is the same value when I go to the toilet. It's exactly the same. So just to explain you. But of course, the warrant of arrest is limited. And maybe the best place for Putin to be is exactly in the United States. Why? Because the United States are not a signatory, have never signed the Rome Statute of the International Criminal Court. So he will be safe in New York, yes. So, but this was only a parallel observation on the fragility of international law and how fragile international criminal law is. Because we have a court, International Criminal Court, which has jurisdiction only over countries which have accepted its jurisdiction. It's not, the International Criminal Court does not have universal jurisdiction. No, only the countries who have accepted its jurisdiction. Yes, technically, if Putin were in Portugal, Portugal could technically, theoretically, could arrest him. Of course, Portugal would not run the risk of disappearing in 24 hours. But I mean, so that would be only a theoretically possibility. So, but bringing back us to the reasoning of self-defense, that is an up-to-date concept that Israel is using. The question that we're facing here is that the concept of international self-defense that is enshrined in Article 51 of the UN Charter comes up to the notion of self-defense from domestic law. And when we're talking about, let's see, my student, he has the umbrella. If he hits me with the umbrella, I suffered a hit and I hit back with another umbrella if I keep the principle of proportionality. But if I see him or her raising the umbrella into my direction, the threat is not, it's still a threat, but it's nothing but a threat. So there is an imminent risk. Okay, then I could use self-defense as well. So internationally, you bringing this back into the concept of self-defense in an international way, what we could say is that a country thinks that another country is going to use weapons against him, and then he uses, using the concept of self-defense. But then let's go further, and this concept of self-defense originally was based on an actual aggression or then an imminent aggression, something that has occurred or something that could occur. But after the September 11 attack on the Twin Towers, this concept has evolved, and the Bush administration says that the modern warfare and the recent innovations in military technology, which may also be employed by non-state actors engaged in terrorist activities, changed the whole calculus in self-defense. So, for the first time, we will have another concept of self-defense, a very modern concept that only came after September 11 attack, and it is called preemptive, not preventive, preemptive self-defense. Preventive is something that someone is with the umbrella in order to hit me, and I act in self-defense to prevent that to happen. That's one thing. Something else is preemptive self-defense, is a new concept. It was used to justify the Second Gulf War. In 2003, the United States claimed that they were acting in preemptive self-defense. Why? Because they were claiming that Iraq has weapons of mass destruction, and therefore there was a threat to the whole international community, and the United States were acting in preemptive self-defense. Well, that that is a new concept, a modern concept. Now, what has happened with Israel is it's not even a question of it's not a question of preventive self-defense. It's not a question of preemptive self-defense. There was a real attack on October the 7th. There was a real terrorist attack against Israel. And undoubtedly, Israel is using its rights to self-defense. The question is, the right to self-defense has no boundaries, has no limits, because international law also prohibits something called collective punishment. So, what is collective punishment? In the name of self-defense, can a country in the name of self-defense inflict collective punishment on another country? Can a country bomb an hospital or a refugee camp? These are the questions that we are facing now. And because, as we have always heard, international humanitarian law is based on the Geneva Conventions, the 4 Geneva Conventions of 1949, and mainly the 4th Geneva Convention, that is on the question of the civilian population. The other ones, one about the treatment of prisoners of war, treatments of people who were wounded, and military and so. But the 4th Geneva Convention is on the treatment of the civilian population during wartime. And the question that we are facing nowadays with this war is, to what extent international humanitarian law is being violated, and to what extent are there any limits for the right to self-defense? And these questions have no answer. And this brings us to the beginning, that is how fragile international law is. And that is also brings us to the title of this reflection, that is, are we losing the metaphor? Is international law still alive? That's these questions I leave you with. Thank you.
Muito bem, excelente. Muito obrigado, professor. Thank you very much. Podemos abrir um pequeno período, né, para debate, perguntas do auditório. Então, são bem-vindas. Não sei se esse microfone aqui ainda tem bateria. Mas se tiver, vamos ver. Tem. Alguém tem perguntas? João?
Good afternoon to you all. Thank you very much for your fantastic lecture. Dear Professor Paulo de Brito, I've bring my umbrella for the rain, of course, but if I need an actual lawyer for defending myself, I think you are the right guy for the job. Thank you very much for your philosophical approach and international law in a matter of war that are coming closer to this region ever and ever more than we desire. Do you think Portugal can, as we can see, have good lecturers, good professors of law, good international law teachers? Could Portugal make a difference between the new conflicts in war, care in Palestine or in Russia, or we are a small country within the southern north of Europe without saying in the matter? What do you think about it?
Well, I think Portugal can make a difference. And all of us know that General Secretary of the United Nations is a Portuguese. We all know that the director of the International Organization for Migrations is also a Portuguese. And obviously, to begin with, no General Secretary of the United Nations can have a job without having consensus from the 5 permanent members of the United Nations, of the 5 permanent members of the Security Council. So I mean, if Mr. Guterres erased that support, I think recently it was Spain recognized his value just yesterday. For his defense of the rights of the Palestinians. So I think, yes, I think sometimes we look at Portugal as a country nearby the sea, but we are a country where many relevant people within all over the world are set. So actually, we are like the Jews in a way that our diaspora has spread all over the world. So we are good position. If you read the RG, Tintin, well, Sr. Oliveira da Figueira was all over the world selling something. He's a Portuguese guy. I mean, so yes, I think we can do something, but the problem is that the motives for war are are sometimes not so clear. We don't know what has really triggered the war. I mean, of course, in what respects to Putin, I mean, it was obvious that he was his desire of inheriting Peter the Great's role in a great Russia, and that Ukraine belonged ultimately to Russia. It was something that we could take over in 2 weeks, and that we can understand. Well, we can understand the motives, obviously, not to justify the imperialism, especially in the 21st century. But this attack orchestrated by Hamas, that was already planned. That was already planned for some time. We don't know how long, but it was planned. We don't know what has exactly triggered that. Iran, Russia itself, in order to shift the focus from Ukraine to the Middle East. I mean, if the United States engage in a protection of Israel, they could support less Ukraine. So the motives, the underlying reasons for this attack are very unclear. And Israel is a country that, if you see, for instance, the population, the Palestinians may be 3 times, 4 times more bigger, the Palestinian population 4 times, 3 times bigger than the Israelis. So Israel is faced with no other alternative. On the other hand, the question is very, very complicated because Israel has nuclear weapons, and Iran not yet, but is close to have nuclear weapons as well. So a student once asked me, oh, well, if we could use, I would use something from Noam Chomsky. He wrote something very interesting that I agree entirely. And he said something like this: the international society remains as it has always been, the rule of law for the weak, the rule of force for the strong. And students asked me, oh, do all countries have to abide by international law? I said, well, Portugal has to, but all of them, no. Obviously, those who have nuclear weapons, they don't have to abide by anything. North Korea could say, oh, this is international law. This is a resolution from the UN Security Council. Oh, really? So have a good day. I mean, we have nuclear weapons. I mean, they don't even belong to the United Nations. North Korea doesn't even belong to the United Nations. What do they care about the UN Security Council? So actually, it is like for many years that countries cannot use force in order to get, if there is a debt between one country lends money to another country and then does not pay. Before the Van Hague Convention, it was possible to use force. Since the start of last century, it's not possible anymore. But even if it would be, one of the countries has one of the biggest debts, United States, will say, okay, China is a creditor. Okay, come here to get your credits. So I mean. So in a way, yes, it's the rule of force, and the rule of law is left for those like Portugal that have to abide by the rule of law, that have to abide by the Troika, because otherwise they say, well, you should not pay. It's impossible for a country like us. So yes, but yes, we could have our academic community, our Portuguese that are placed on key positions in the United States, they could make a difference. Yes. Yes, my answer is clearly yes.
Great answer. Thank you very much.
My pleasure.
Dear colleague Tomás, Your Honor, thank you very much for coming. I hopefully you can, this time or another time around, come to Coimbra to meet our great ancient university that I kind of represent a little bit in here, as Professor Paulo de Brito also, from his early student years, before me, of course. As it noticed, I have a question from contemporary constitutional Portuguese law. How is the Polish constitution? Is it a book as our constitution, a combined positivity book with the name Polish constitution, or it is kind of a ruling like English or American constitution that has many books, many years of studying, many jurisprudence that you can combine in your office to get a sentence? Mm-hmm. Thank you very much.
Okay, thank you very much. Maybe in the future I will go to Coimbra. I don't know. This is my second time in Portugal, so we'll see. If I can say about your question, we have booked constitution, not like a common law system. So we have book our constitution. As I don't remember, but I can check during the break. But is over 200 articles. I don't remember. Because I know these articles or what I need. But I can check. We have no system like common law, but of course jurisdiction is very important, and verdicts, decisions of courts, especially appeals courts and Supreme Court. The Supreme Court are used in cases. But only rules of Supreme Court of the Supreme Court are common for and are used to other by other courts. Our judges are independent in jurisdiction, so of course, can use others course decision, but it's not obvious. So can, but it's but can't. So yes, definitely. This is our system. Mhm.
Mais perguntas? Questions? Okay.
Good afternoon. After all, I will like to also thank all the members of the panel. I wouldn't miss this opportunity to, because we have here Professor Thomas and also Professor Igor, to make a kind of question. It's also legal. I don't know if you can answer because of being a bit of political also. I think that we all have known that in the recent times, we have seen Poland arguing with the EU about the situation of the jurisdiction of the European Union in Poland, and also some question about, for instance, the human rights, about the abortion law in Poland. And because we were talking about the constitution, and we have now clarified that we also have a system similar to ours, not as in the common law, I would like to know, if not the political view, because I know because of the statute, at least here it's something that can't happen, at least in the kind of the procedure, how has that been enrolling in Poland? And that was the kind of question that I would like to address.
Are you asking about immigrants from other countries on borders? I can hear you. Mm-hmm. Abortion. Oh.
And also the situation of that the Polish government was saying that the European jurisdiction, the directives, the statutes, they don't apply, they don't prevail to the Polish, something that all the European countries have accepted by getting into the EU.
Okay. How to say? It's not my area, the first of all, because it's rather criminal and constitutional cases, not for me. I'm civilist only, so it's definitely other area. So I can say only that our constitutional tribunal made a verdict which composed of most protests of society in Poland, and that's all. We have this kind of situation that we have verdicts of our constitutional tribunal, and we have verdicts, points of view, international tribunals. So that's all in this case. Sorry.
No. Thank you.
Para o microfone porque temos um público online. Mais colegas querem fazer? Colegas? Pergunta online. Só um minuto. Essa pergunta é para o professor Paulo de Brito. Aqui tem, pode ler, por favor. Aqui essa última.
Sim, de Marrocos.
Como podemos...
She's asking whether we could treat international law as the same level of coerciveness as internal law. No, obviously not. I mean, it's not as coercive as domestic law. But the fact, and the examples are clear that I gave, but the fact that is not as coercive, does it mean that for that fact is not law? That is the question. And my view is that still law, but it's an imperfect kind of law it's law in terms of validity, but maybe it's not maybe, but it's undoubtedly less effective, much less effective than domestic law, and much less coercive than domestic law, but it is still law.
Obrigado. Thank you for the question, Taha, from Morocco. Nosso congresso é internacional mesmo, né? More question, mais perguntas. Se não tivermos perguntas, exatamente falta 2 minutos para o intervalo. Vamos fazer o intervalo. Quero agradecer, to thank the speakers, né? Professor Tomás e professor Paulo de Brito, por suas palestras. Agradecer nesse primeiro momento, né, os nossos participantes. Espero que fiquem aqui online. Vamos fazer um intervalo de 30 minutos, porque queremos conversar bastante com os colegas. Um intervalo mais ou menos de 30 minutos. E depois voltaremos no segundo bloco com o professor Igor e o professor João Proença Xavier e a professora Luísa. O professor Igor é também ministro do Supremo Tribunal de Justiça da Polônia, assim como o professor Tomás. E o professor João Proença de Coimbra, muitos já conhecem, e a professora Luísa é aqui da nossa casa. Muito obrigado a todos nesse primeiro painel. Queria convidar todos os alunos e os presentes para virem aqui para nós tirarmos uma foto para os nossos colegas polacos levarem lá para a Polônia. E nós também vamos publicar nas nossas redes. Muito obrigado. Ok, thank you very much.
Break, no?
Break. Podem vir todos aqui, vamos tirar uma foto aqui na frente. será já apresentado, o professor João Xavier e a professora Luísa Barros. Esse conferencista, já quero agradecer for your sending e agradecer por ter aceitado participar dessa conferência. Quero saudar todos os alunos que mestraram em Direito Empresarial, Direito Empresarial, aqui na Universidade de Lusófona, que estão presentes no nosso auditório, assim como nossos convidados que vieram participar desse evento. João, por favor, se quiser já tomar a iniciativa, bem-vindo.
Olá a todos e todas, boa tarde, bem-vindos à Lusófona do Porto. É um honor poder estar aqui nesta casa, a qual também pertenço, neste caso, ao Resto de Lisboa, apesar de ser do IBEROJUR e da Universidade, neste caso, do Universidade também. É uma honra imensa poder partilhar, desde pela primeira vez, a mesa que temos de colega Lisa Navarro, ela própria também está salamente de Província Cultural. E, no caso, a nossa companheira, professora e investigadora de outros trabalhos internacionais através do projeto IBEROJUR, e agora, desde este ano letivo, espero que acontecer, inteligentemente, nossos alunos, é professora aqui desta casa, uma decisão fantástica para ela, para a carreira académica que ela segue em breve, e para estes alunos, para esta instituição, da qual também o presidente do IBEROJUR e também o professor de Direito de Disciplina, o professor Fábio Veiga, faz a honra também de ser presidente. E agora, vou fazer a minha dualidade, que é vou usar aqui a minha carta internacional para poder apresentar o meu ilustrador. Neste caso, colega do Direito Académico da Tecnologia, and now in English, I guess English for either talking Zorinski, I'm going to Poland in a few months, so I must practice my Polish. Here, Igor is professor on the Watch and Promotion Academy on Bodybuilding in Paris. Vice Chair for Science in this university, and of course, in Poland and is the chair of critical in the Filipino chair. As a legal but not legal, is the chair leading the of his opinion. Background in Filipino law and rules and procedures dedicated to the fair implementation of law with the defense of legitimity, interests, and rules. So, he was well represented, a well-known professor of law and criminal Supreme Court chair. Igor is a next honor to participate in this day with you and this university. I hope we can come back as soon as possible. Perhaps I also invite you to come to England for the school for the rest of the Thank you very much. I think you are going to speak about more of the additional periods. It is a very important issue here at all as student and student of sure we very and we will be very thank you very much.
Thank you, Suárez. Bom dia. Eu thank you very much for the invitation. It's very welcome to me and being here today. Special words to Fábio for this meeting. I will try to keep time frame because the sound main issues of sound system like I have a few pictures for you about him. Lá durante o período de estudante, durante a aula, durante o cheio de trabalhos de dicas, então escreviam lá durante a aula de treino with a growth of other things that we need to social that we analyze the growth. The problems of private employees and however, it's already more nothing to the point that the time ago we integrated some product is then create more to insurance and life. That we go and you understand, you know, international law, we just talk about it, few weeks ago, check my words of law, the legal side, the legal solution, within the international law, the first thing, the international legal for exchange and the ruling that for us the deadline will be all the time. It is an example of the university. I have been told all over this situation and the house completed, and which my government and something became with the ASA. With the progress of the election,
The verbiage has significant changes at its face. What is noticeable, however, is in the phenomenon of low but systematic spirit of transitional justice and thus on increase in the importance of the norms established for this purpose. Settlement events in the past are now becoming a frequent phenomenon and are also increasingly subject to the regulation of relevance law. They are therefore evolving towards being put info some more or less detailed forward framework with a move away from sudden unplanned events. This is how the transformation is institutionalized. So the properly illustrated issue at hand is worth looking a little closer at history, where examples of application of this reaction have been numerous. Some of the earliest reorientation include the abolition of the monarchical system in England, of circumstances surrounding the fall of the monarchy, and the trial of Louis XVI in France. The so-called July Revolution and the cessation of regime de Charles X can be seen in a pledges press within the framework of modern history. The settlements with Nazism or the transition towards democracy that occurred in Europe can be seen as such events. Above all, a major contribution to the development of transitional mechanisms was seen in the third wave of democratization. It affects a fairly wide spectrum of countries across Europe, Asia, and also Latin America, The beginning of this wave was the so-called Carnation Revolution here in Portugal and the fall of colonist regime in Greece. It was not long before the transformation spread to countries such as India, Pakistan, Chile, and European countries, demolished in the countries in Central and Eastern Europe, like Eastern Germany or Poland. Yeah. In the following period, however, the Arab Spring emerged with transition extending to countries such as Tunisia, Egypt, Libya, and Syria. Maybe this one. Yes. The international law of transit. A completely different issue is the law of the transition period internally. An example of this is the French decree on 28th October 1944 on the punishment of collaboration. On the basis of this piece of legislation, special courts were set up in post-war France, attached to courts and appeal level, set up to adjudicate on acts that constitute criminal offenses, but committed for the purpose of inter alia assisting in actions of the invader. Convictions for such acts mean that the defendants were automatically deprived of their civil and honorable rights. In the context under discussion, one can also point out the numerous changing in Polish legal regulation with regard to persons who are included on the German nationality list. It means the Deutsche Volksliste, a relevant decree on the German nationality list and German state affiliation in the incorporated Eastern Territories was issued on 4th March 1941. After liberation from Nazi occupation, a separate criminal law regulation was issued, as these behaviors were generally regarded by the public as collaboration and constitute war crimes. Settlement model of the past. Undoubtedly, the most being of response is a completely abandonment by the state to settle the past. This is so-called amnesia model, but the name does not seem to capture the essence. Direction is not to forget the past period, but to consistently abandon to its accountability. It's in model this occurs quite rarely. A common denominator, a social objective, is necessary for its implementation. It's worth mentioning that this passivity of the state may be accompanied by strong emotion in some circles, as forgiveness and reconciliation usually take place after a certain period of time. At the opposite end of the spectrum, from the point of view of the consequences to this subjected to verification mechanisms, two basic models have developed. The first can be reduced to the implementation of different types of sanctions. This path seems to lie not far from criminalization. It's true that stricter criminalization actions can be prosecuted by means of generally applicable norms, but generally in transitional states, the phenomenon of a specific norms for this purpose is apparent. The second model can be described as a historical clarification. In this model, the activities of states authorized focus on the creation of legal mechanisms for reaching the material truth, including by means of special historical research. In between these two models, so to speak, there are of course various mixed models which draw detailed solutions from both. A well-established academic distinction based strictly on the reaction towards two preparators. It's distinguished four types of behavior: A, absolutive tick line model; B, relative tick dash model; C, criminal prosecution model; and D, reconciliation model. And now Polish. A few words about Polish vetting law. I think a few words should also be devoted to the recent transit regulation that we were introduced in Poland. The state response after the collapse of the regime occurred in 1997 and was substantially modified in 2006. It was stood quite late compared to other Central and Eastern European countries. Now, Polish lustration proceedings are a special type of proceeding located between traditional criminal proceedings and proceedings aimed to a historical clarification. However, it remains a repressive procedure. The regulation of the Act 18 October 2006 on dislocation information on documents of state security bodies from the period between 1944 and 1990. And the countries of such document cover persons before August 1972. And now we can forward. And here, summarizing, summarizing. Oh, yes, it's correct, yeah. So, summarizing the issues presented, it should be stated that transit is a clearly visible phenomenon in history. It encompasses a broad spectrum of issues, not only the field of law, and goes significantly beyond these issues, becoming the subject of many social sciences. The various solutions can be analyzed both internationally, including comparative law, and using a border perspective, and internationally in a narrower perspective. There is a multiplicity of legal transitional solutions, which consist of many aspects ranging from the culture of given nation to legal traditions. They are, however, certain elements to that coverage on the legal solutions of the individual states that have had to embark on the transition path. This is essentially due to the desire to respect human rights standard, which is observable in most of these states. In the international aspect, also in the context of the current armed conflict across the eastern border, a new debate on the collective international elaboration of transit minima becomes necessary. I mean, it's war in Ukraine. They should be enshrined in a single relativity delete legal act in the form of an international agreement, accompanied and sanctions. Failure to comply with them should be consistently recognized by international bodies as a breach of the transit standards and be associated with multiple sanctions. And that's all from me. Thank you for attention.
Before speaking, I want to say something. As most of you will know, I'm also, besides a teacher, a European lawyer. And sometime in my career, I thought when I was a law student, I can, not easily, but I hope to be a judge. Sometime along the way, along the shares of the university, the Faculty of Law of the University of Coimbra, I discovered I prefer to be a lawyer. And now that I know my dear colleague, Igor Dominic, I know why. I know why or where you get your gray hair. In your office, dear colleague and your honor, because you have explained in about 10 to 12 minutes the difficult place that you are in for 20 years on the road. To decide to be a judge, it's a thing that needs its courage. To become a lawyer also, but I'm a defense lawyer. I'm trying to defend my clients, my point of view, human rights, wherever I can go. But you have the hard and burdening task of deciding if it's right or wrong. It's if you can go free, if you are not, if you can have a small sanction, or you must get almost life. And you are not a Portuguese, you are a Polish judge from the heart. and from the heart of the country that is in the center of wars for every year I can remember of. We have the Germans, we have the Nazis, mostly occupying this territory for decades. You have to struggle with being raped, with being destroyed, with being almost wiped from the face of Poland. You must rebuild yourself. And then when the war is over in 1945, we have the Russians at your state, and they go and take it over for them. And then you cannot be Polish again. This is an Asian people. This is a very proud country. I'm always very happy to be there because that's when I'm in Poland, wherever I come, within in courts, within in the land, in the university, even on the plane getting to Poland, I know bad things happen there, and they still smile. They're still fighting. They still go to work as lawyers. They still go to the bench of the judge, and they have to make justice, to make it right, but the other ones make it wrong to them, and they must forgive them. They do not need to apply the rules as we do here in Portugal or in Spain or in France or in Italy. They must heal the land. This is the Supreme Court judges' work of life. So you and Tomás and Marius that is not in here, and it is also a great lawyer. I know he bleeds a little bit because for becoming a judge, he must no longer be a lawyer. But I think it will be a best judge being a lawyer before. And then I think he can do as you can do both, better for the land, because you can save with your decisions the whole country, the country of old people, new students, of new future. And as a lawyer, as I am, you only can save one at a time, one of the case. And with your rulings of your 20 years on the bench, you are trying to do almost the impossible, not only to be right, not only to be righteous, but to be true, not too much punitive, because the people have suffered enough, but not too quite soft to do not mean anything. So it will be a great honor for me to can go to Poland and see you work in your office, because you are Polish, and because you are in the Supreme Court in the 21st century, has a place with meaning in law, but the harshest thing to do in judges kind of history for your country. That's why I thank you, and I know for sure that you are both doing a great job, and a difficult one that you cannot say that you are, but you know that you are. Thank you, Igor. Thank you, Tomás, for your fantastic work and for showing us here in Iberia that one guy in the Supreme Court, in an office, can really make a difference. Thank you very much. Thank you. Yes, please. Sorry.
Thank you, Igor. Very good speech. Thank you very much. Vou apresentar agora o professor João Proença Xavier, porque cabe a mim apresentá-lo como coordenador e como colega e amigo. O professor João Proença Xavier é professor da Coimbra Business School e também é investigador do 620 da Universidade de Coimbra. É doutorado em Direito pela Universidade de Salamanca, pós-doutoramento em Direito pela Universidade de Salamanca também, e licenciado pela Universidade de Coimbra. Então, ele é coimbrense e salamantino, as duas coisas. É um especialista em direitos humanos, né? A área de especialidade dele é nessa área, mas hoje ele vem falar aqui um tema bem interessante para nós, Women in Company Leadership Positions, né? As mulheres que estão nas empresas, que tem a ver com meus estudantes também que estudam direito empresarial, em posição de liderança. E o João tem aí um bom assunto, bem polêmico para tratar, né? Entre competição, né, nos altos cargos, né, de direção de empresas e com relação às mulheres. Vamos ver aí a posição do professor João Proença Xavier. Vocês já podem preparar as perguntas para o final, né? Bem-vindo, professor João Proença, aqui à sua casa.
Muito obrigado, Fábio Veiga. É uma honra continuar a colaborar com os projetos do IBEROJUR, onde eu também tenho o imenso gosto e a responsabilidade de ser coordenador da área de Direito de Bioética e Direito Biomédico desta magnífica instituição colaboradora deste congresso e, naturalmente, eu, como membro da Faculdade de Ciências da Vida da Universidade Lusófona de Lisboa, também me sinto em casa aqui na Lusófona do Porto, onde eu comecei sempre a colaborar mais cedo do que a minha colaboração contratual com a Universidade, com as Ciências da Vida, no caso, onde eu leciono legislação para a reprodução humana assistida, no primeiro e único curso de Embriologia e Reprodução Humana de Portugal. Irei falar em inglês, naturalmente, para os meus pares me poderem perceber, mas basicamente vou traduzir o meu título dizendo aquilo que eu dizia aqui aos colegas em off. Numa turma mais ou menos de Direito Constitucional Contemporâneo, eu terei aproximadamente 80 mulheres e 20 homens. Mais ou menos a proporção que eu tenho aqui, sendo que aqui também já está desequilibrada. Temos 3 homens e uma mulher. Não estivesse aqui a Luísa Brandão Barrios e estaria de género a mesa completamente desequilibrada, como é costume estar. A mesa anterior, não desfazendo nos meus queridíssimos antecessores e colegas, tinha 3 homens. Aqui tem 2 homens à frente, mas depois 2 homens atrás. Mas depois tendencialmente matizado um ou outro no meio, mas depois consigo ver aqui quase diretamente 20 senhoras. A questão é se as universidades estão a produzir ciência com excelentes notas e com bom desenvolvimento, no caso, no Supremo Corte, no caso da Polónia, também temos 2 representantes masculinos, mas no futuro não haverá alunos com notas suficientes para entrar no Supremo Corte ou no Tribunal Constitucional Português, portanto vão ter que ser juízas, vão ter que ser alunas. E muito bem, será que os homens vão precisar de cotas nessa altura? E a pergunta do $1 million, será que elas vão receber o mesmo? Não tinha por que não receberem. Mas bem, como lá não tem chegado nenhumas, é possível que aconteça a mesma coisa que acontece em algumas empresas, que recebem menos. Era interessante ter aqui a professora Rosário para a gente fazer a estatística aqui na casa, se os colegas masculinos e femininos recebem a mesma coisa para as mesmas horas, e imagino que agora, no século XXI, isso já aconteça numa universidade progressista como é esta, mas quando começou, não era assim. Então o meu tema, and now in English, for everyone to can understand me, it will be Women in Company Leadership Positions, Gender Analysis from a Portuguese perspective. This is a gender-orientated scientific work. This is a methodology. So for you guys and girls that are out there, they are students, they are researchers, they are professors and colleagues, they are judges, you should know it's not the same. It's not the color of the eyes, it's not the makeup, it's not the high heels, it's the salary. Men and women are both humans. They are destinatory of human rights. So it's right, and in a state of right, that law should be applied equally to everyone. But really, even nowadays, doesn't happen that way, unfortunately. So this work aims to analyze a systematic review of studies on the impact of COVID-19 on gender inequality, discussing the role of women in the labor market in statistically significant analysis that the participation of women in various roles as a professional, wife, mother, and educator promotes social well-being and contributes to the economy and political stability of countries. When all is equal, there are not wars. So if it's equal pay, equal work, there's no quarrel. But really, it doesn't happen the direct way as we see it in this work. It's not enough to have laws and strategic plans to solve the crisis that ensured from COVID-19 pandemic. Affirmatives will have to be found, reinforcing institutional mechanisms to establish the effectiveness of integrating of women in equal positions to men, in company leadership positions, not in every position, because you can have a CEO that's a guy and cleaning assistant or 10 cleaning assistants, they are women or girls. This is not equal because the CEO will earn about 25 or 30 or 100,000 euros and the cleaning assistant less than 1,000 euros. So we are talking about same work, same pay in leadership company positions. So the integration of women in positions equal to men without discriminating in age, motivation, and in productivity. So this paper presents a theoretical reflection in how COVID-19 impacted in gender inequality. So this is a twist, a scientific twist. We are not equal. We are tending to be equal. You should be equal, but we are not. And with COVID-19, we go back ages, mostly kind of dictatorial terms in terms of political constitutional history in Portugal. So paying particular attention to the role of women as professionals in the fight against pandemic, but also to their contributions to economy throughout unpaid work done in the home environment, that is not counting. Women take care of men, take care of children, take care of elderly without pay. Men do not do anything without pay. You already know this. According to even if you are a guy, you know this, but if you are a woman and a clever woman as you are, you also know this. And this is not right. The country is enriching itself with work that has no pay, even in Portugal today. According to the World Health Organization, women continue to make on several roles at the same time as workers. There are not simple workers. I'm a lawyer, I go to my office, I go to my classes. I should do more. Women make time as professional workers, careers, wives, mothers, and educators, resulting in high levels of anxiety and depression for them, nor for their husbands, nor for their companionships, nor for their children or their fathers. It therefore comes as no surprise, unfortunately, that women are struggling globally to move up the institutional ladder, the institutional hierarchy, the institutional elevator, that is university, for instance. You are in here, you are 7 and 80% more than men. Are you getting the nicest jobs when you get out of the university? Perhaps not. The guys on the suits are going to take your money, unfortunately. But in the end, it's going to have a class that have no men. And in the future, the men that are still standing don't have the education good enough to have a master's degree, to have a PhD, to have a post-PhD. So it will become that women will get there eventually. Do they earn the same amount of money of men in the same position? I hope so. If not, I'm not. This work is not for anything. It doesn't. Is not only for points for my university. It means to make a difference in society. If not, I'm not a good investigator or researcher, and my role as a teacher is kind of a tape recorder. It's better to hear a recorded class than hear me all the way around. So this echoes in this room, but it must echoes into society and to governments and within law
and judges, of course. Therefore, comes as no surprise that women are struggling going globally to move up that stair. In 2019, female healthcare workers accounted for 7% of functions, but only 25% held leadership positions. So, of all women, 7% have a job, 70% have a job, that's good, but only 25 of them, of that 70%, have a top job. They were presidents of everything. They were in the center of the table, not in the end. Perhaps we are going to change when Luisa is going to speak. It will be very nice. And he's better looking than me, so it's good for you all. In the 21st century, women continue to be excluded from senior positions in public and in private companies and institutions to senior positions and earn on average 20% less than men. This is professional data from National Minister Resolution Council of Portugal. This will be exacerbated if public or private institutions fail to implement the intervention politics for equality, gender, citizenship, and non-discrimination, and if such politics do not abide for the previous resolutions of the Council of Ministers of Portugal from 2018, National Strategy for Equality and Non-Discrimination, 230. It's still time, but it's still time to pick up. It's still time for you to get the nice jobs and to have the pay that you deserve. But really, in this time, 2023, it doesn't cut it. If you have the job, you have a lower job than the guy. And if you have the same job of the guy in another company, you will earn 20% less. That it's not right. Even in constitutional terms or human rights terms, in anyone terms. In Portugal, to address the national emergency resulting from impact of COVID-19, Decree of Law 10A 2020 of 13 of March present a number of extraordinary and urgent measures determined by the government on the provision, containment, migration and treatment of patients infected with the SARS-CoV-2 coronavirus. Accordingly, with a view of stabilization the National Health Service, the SNS in Portugal, regarding to the hiring of staff, the former current minister, my dear colleague and friend from the University of Coimbra, Dr. Marta Temido, delegated that top health leaders have the power to organize and hiring professionals really to make their duties immediately, who has exempted from any other formalities. They could hire anyone for the time they want because it was a national necessity as a laid down ministerial order, stressing the need to ensure the effectiveness and effectiveness of SNS national health system at the time when are undergoing a second pandemic wave, an increasing number of infected people of morbidity and great morbidity caused by the new coronavirus. All health professionals are in paid employment, given important level of contribution. There were women in the first line. Pointing to Amina Mohamed's stand that gender inequality is crucial, or equality is crucial for the effectiveness of the organization work. This situation will naturally be assured later by researchers when the pandemic is under control. Perhaps now we are going to study if that women that were hired by this decree to work in health departments, hospitals, and everywhere were paid by the same dollar, by the same euro that does the men do. Official data obtained from the following websites: World Health Organization, European Commission, United Nations, European Parliament, European Institute of Gender Inequality, International Labour Organization, Portuguese Government, Commission of Equality and Labour Employment, Pordata, and so on, and the Scientific Repository of the University of Coimbra, and Portuguese official journals, and obtained legislation on these matters tell us that they do not apply for equality. So really, they hire the workers, they hire the women, they are well qualified, but they were not on the system, they were needed, but when the pandemic is closed, or more or less on sale, they go out of the system with no pay, with their families to support, with the child to support, with their natural unpaid jobs to do. And the guys that were in the system still are in the system earning the best top dollar position. So, despite the strong consistency of the results found on this subject, and is still necessary the question of management of family life. So we know that women are less hired, they are less paid for the same positions, and they still do work for free. They do the food, they clean the house, they take care of the children, they take care of the elderly, they take care of the sick, not in the hospital, at their home without any pay. And this is good for the country, but bad for them, obviously. So this work means also to translate, that is also bad for the country. Because if they aren't paid for that, they should have a compensation. And even when they applied for a job, they should get it if they are qualified for it. And at first time, they should get the better jobs they can get with their resume, with their qualifyings, and they should have top dollar. If a guy in that position earned $2,000, a girl should have $2,000, 2,000 euros. But that doesn't happen because normally in higher positions, they are men and they discriminate. They hire women because they don't have other alternative, but they pay not less, not quite less, but a little less, 20% less. So if a paying job will have to pay 100 euros to a guy, approximately a girl for the same position will earn 800 euros, 200 euros less. It's much money that the company is keeping, and it's not right. And she is overstressed, she is unpaid at home, and the country is getting poorer, in my humble and scientific opinion. This is corroborated by a study conducted by the University of Lisbon in 2015, which concluded that Portuguese couples who live together and both work full-time and have well-defined as a particular housewife finances have weathered the economic crisis well because they both have work. However, if the crisis worsens it, like we have today, as it longers, it's necessary to invent a longitudinal studies to assess if in that couple, for the same positions, more or less the same time of work, they earn the same. Because they are together, and they are economically together, and they are mostly romantic together, it doesn't show because they can survive the crisis of COVID-19 because he earns 1,000 euros or 2,000 euros and she earns 107 and 600 euros or 800 euros. And the both can kind of cloud it, the judgment, and perhaps they feel they are not being differently paid. But statistics and data, official data, cries out that women and men in Portuguese or in Portugal of the 21st century earn today in 2023 to 20% less. And in the bottom of the column, we are not talking about managing positions, not directing, not CEOs. In banks, you should go outside and go to for a bancary dinner, Christmas dinner, and they have women and men working there. But if you go to the CEO's dinner, there are only men, perhaps one woman, and one is one of the wives of the CEOs. There are no women in top banks. There are no women in parliament top positions. There are no women ministers. There are no women first ladies on the parliament. There are women on the parliament, and they actually earn the same pay that men. But the president of government, not today, that's he goes, he's expired his position, but it was a man. The president, it's a man. The secretary of state, it's a man. The minister, it's a man, and so on and so on. So the girls earn less in the same position and don't have the fighting possibilities to get the top jobs, the ones they pay really not good, but quite better than other ones. So in conclusion, equal pay between men and women in Portugal is monitored, and entities are aware of the need to produce statistical information on pay differences for equal functions and positions based on the principle of data transparency upheld by the government, which may decide and mitigate the gender inequality aggraved by the COVID-19 that goes beyond the threat to public health. Public health issues are not big issue today. COVID-19 is kind of behind our backs. So men and women should be the issue, in equal pay for equal work should be the constitutional good thing to do. The vulnerability of women at this moment is a fact of uncertainty, and the denial of gender inequality is persistent between men, of course, but within women. They are ashamed to say anything, or they do not realize of that because most of you or most of them are married, and the proportional money dividing by two kind of wipe under the rug the differences of the salary. After 40 years, leveling the rights of men and women within the family, this is still a long way to go, as the asymmetries must be corrected. This is an unacceptable situation, given that many policies for intervention have been implemented in this regards. The question is, what could be going wrong with the measures implemented in democratic countries such as Portugal in a faithful European Union guidelines? So I'm a European Union professor. The guidelines are very strict. They are very transparent. Men and women should get the same opportunities and get the same pay. Why do if you go to the real world, that doesn't happen? We can thus conclude that entities such as the Commission for Equality in Labor and in Employment have been instrumental in identifying, not modifying, identifying the situations of discrimination between men and women in the Portuguese labor market in this title that we have bring us in company leadership positions mostly. So the results of this research suggest that talking about gender inequality is the same as accepting that there are differences in fact, and the opportunities available to men and women are different, and that itself impacts in labor market and family personal life. Several authors argue to the problem resulting from gender inequality prevents countries from achieving a better indices. So this statement suggests a change in these systems and traditional mechanisms are needed, which are sometimes made by prejudice and stereotypes that prevent women and countries from achieving their potential in work, in family, and in life. Thank you very much. Try to learn the same thing and still struggle. Thank you very much. Okay. There's no votes for me.
Thank you very much, Professor John Proença Xavier. Muito obrigado. Muito obrigado pela sua exposição. Se tivermos perguntas, fica para depois da palestra da professora Luísa, para a gente deixar para o final essas perguntas, tá bem? Porque os alunos estão, teoricamente, os alunos do mestrado podem ficar até as 9 da noite, teoricamente, né? Só que mas nós vamos terminar bem antes. Vou apresentar a professora Luísa Brandão Barrios, ela é doutora em Direito pela Universidade de Salamanca, também pós-doutora em Direito pela Universidade de Salamanca também, onde fez a sua carreira de doutoramento e pós-doutoramento. Aqui do Porto, natural aqui da região, né? Ou é do Trás-os-Montes? É aqui, né? É o pai que é de Trás-os-Montes, isso mesmo. A mãe da Angola, pai de Trás-os-Montes, e ela nasceu aqui no Porto, né? Bem internacional. E desde esse ano ela é professora aqui da nossa universidade, e isso, eu fico muito alegre, porque eu também sou amigo da professora Luísa, praticamente mais de um ano, né? Quase 2 anos. Ela já esteve também na Polônia, foi num congresso ano passado, nós estivemos lá, em Cracóvia, e França, aqui em Portugal, em vários lugares, né? Espanha. Bom, só falta o Brasil, porque ela estuda também direito indígena. Falei para ela, tem que levarmos ela para o Brasil. Já que ela gosta dos índios, vamos levar lá para a floresta amazônica. Professora Luísa, ela escolheu um tema, então, que tem a ver com seus estudos, que ela também estuda e dá aula em direito administrativo e direito do ambiente. Quem faz mestrado na área de direito público, ela também é professora. Escolheu o tema drones e meio ambiente, né, uma sinergia para o futuro. Só vou explicar aqui a questão da professora Luísa ter ficado no final, né, por causa da palestra do professor aqui, João, para não dizer que ela foi excluída. Dentro da universidade existe uma questão de antiguidade de quem tem doutorado, né? E aí, por norma, o último doutor é o último a falar. Então, aqui de todos que estão aqui na mesa, ela é a mais jovem doutora. Só por causa disso. É um critério bem objetivo, né? Daqui uns dias ela vai ser a primeira, daqui uns 10 anos, né? Obrigado, professora Luísa.
Então já era aqui Isto o microfone está lá para trás, né? Muito obrigada. Antes da minha breve apresentação sobre os drones, o meio ambiente, isso, foi o tema que eu escolhi, sinergias para o futuro. Eu gostaria de aproveitar um minuto destas 2 horas que eu tenho para falar sobre o meu tema. Gostaria de aproveitar um minuto do meu discurso, em primeiro lugar, para agradecer ao convite do Sr. Presidente do IBEROJUR, o professor Dr. Fábio Veiga. É meu companheiro, de facto, nesta universidade, desde há pouco tempo, mas também foi companheiro foi a partir do foi a primeira vez que eu estive aqui, na Lusófona, foi há 2 anos precisamente, a falar português, porque eu sempre fui a congressos internacionais, e foi com o IBEROJUR. Logo, temos uma relação de realmente proximidade e de estudos, abordamos as mesmas questões, basicamente. E também agradecer as palavras simpáticas que sempre me são dirigidas. Agradecer também, para mim é uma honra estar nesta ilustre mesa, não é? Com também o meu colega e amigo, não é? O Sr. Dr. João Proença, e fazer um pequeno à parte, só dizer aqui uma pequena coisinha relativamente à minha situação aqui lá na Lusófona. Eu gostaria de agradecer a confiança da Universidade por eu estar aqui. realmente foi um ato de confiança, à parte de tudo. E desta vez, ao fim de 2 anos, depois de ter participado aqui como palestrante, como eu já mencionei, a primeira vez na minha cidade e a primeira vez a falar português, e com o IBEROJUR, espera, agora espalhei-me já. E então eu gostava de agradecer e de mencionar exatamente isso. É a minha segunda vez como palestrante, sou professora, mas é emocionante de facto estar na minha cidade e poder falar a minha língua com o meu sotaque. Então, o tema que eu trouxe hoje, já voltando a repetir, é um pouco diferente dos restantes temas que eu tenho trazido a nível nacional e internacional. De facto, eu gosto de estudar os povos indígenas, direitos humanos, as vítimas no processo penal. Realmente fujo um bocadinho para o processo penal. Mas hoje decidi, sim, tomei a liberdade de abordar um tema, é mesmo assim, arrisquei um bocadinho em falar sobre os drones e o meio ambiente, obviamente como uma visão para o futuro. Eu vou tentar ser o mais breve possível, não vos mantenho até às 9, mas até às 9 menos um quarto acho que é suficiente para eu poder falar, já que sou mulher, não é? E tenho poucos minutos para falar, então vou aproveitar as minhas horas para conversar, para falar e tudo mais. Podem também tomar um café se quiserem, entretanto. Então, eu vou começar, senão não termino, não é, doutor João? A pessoa só está a pensar no jantar. Então, eu vou começar pelo fim. Decidi começar pelo fim, digamos assim. Não sei como é que eu ia dizer isto em português, mas não é? Em vez de utilizar o pleonasmo, começar pelo início, eu vou começar pelo fim. Exato. Olha, não sei. Então, a omnipresença da inteligência artificial na vida do ser humano é a fase imediatamente anterior àquilo que podemos chamar a robotização do ser humano. É uma frase, como dizia o doutor Hugo Luz dos Santos, que eu gosto muito de ler os livros deste doutor e aconselho a qualquer pessoa. São livros pequeninos que falam sobre inteligência artificial, machine learning e uma data de informação sobre a inteligência artificial, mas o doutor Hugo Luz dos Santos disse desta forma, e acho que foi realmente assertivo, é uma dantesca frase, digamos assim, da robotização do ser humano, certo? São palavras do Dr. Hugo Luz dos Santos. Que enfraquecerá ou se debilitará, não é? O núcleo essencial da dignidade da pessoa humana, não é? Daqui a uns tempos somos todos robôs. O princípio da dignidade da pessoa humana constitui uma barreira inultrapassável atinente à atividade legislativa dos Estados. Existem também, além deste, outros autores portugueses que debatem estes temas. Temos também Catarina dos Santos Botelho, Francisco Fernandes Segado. Existem variadíssimos livros e variadíssimas opiniões sobre este tema, embora seja um tema bastante controverso e que requer uma leitura mais abrangente, porque não vai ser só com um livro que vamos começar a perceber, é de facto um tema que ainda não está muito regulamentado, não é? Mas todos estes autores, de alguma forma, defendem que a ligação umbilical entre os direitos fundamentais sociais e alguns princípios estruturantes do Estado de Direito tem sido aventada por vários setores autorizados da doutrina. Assistir-se-á ao determinismo tecnológico sob a veste de uma ditadura algorítmica que perspassa todos os quadrantes das nossas vidas cotidianas. Quem entenda como funciona o alicerce vital que subjaz à ditadura está-me a gostar de dizer esta palavra, algorítmica, e as formas de inteligência artificial que propulsam aquela, desempenharão um papel modular no presente e no futuro. Temos outros autores, Jorge Reis Novaes, que fala sobre a dignidade da pessoa humana. Temos Tilde, que é um alemão. O Karlsruhe é bastante falado. O Susskind, para quem já fez muita investigação, também sabe que é um nome um nome relevante nesta área, ou seja, temos uma data de autores portugueses e uma data de autores estrangeiros que já abordaram estas questões. A sorte processual e relativamente ao processo penal, e já agora aqui, fazer daqui um à parte, também gosto de processo penal, não é só direito administrativo. A sorte processual do delinquente será inteiramente determinada através de algoritmos. Porque é que eu estou tanto a falar sobre algoritmos? Porque é um procedimento para resolver questões matemáticas, certo? Então, estas questões matemáticas poderão ser resolvidas passo a passo. São instruções dadas a um computador que ajudará a responder a tais questões, estas questões relacionadas com, neste caso, com a posição do delinquente e com a sua pena, digamos assim, que ditarão com base em parâmetros referenciais de quem reúne ou não os pressupostos para a concessão da liberdade condicional e de quem reúne ou não os pressupostos para a revogação da suspensão da execução da pena de prisão e quem tem ou não a probabilidade algorítmica, lá está, porque eles estão preparados em termos de algoritmos, voltar a cometer crimes ou delitos graves, não é? Há que ter em conta que estes algoritmos tendem a ser discriminatórios. E aqui é uma grave, digamos, uma questão muito interessante, mas isto será para outro, digamos, para outro debate, porque surge esta questão atualmente de que a inteligência artificial tem atos discriminatórios. E porquê? Eles poderão negar tudo a um determinado perfil social, político, étnico, religioso, racial e educacional. Há um livro importante sobre isto. A Anupam Chandler escreveu exatamente sobre o racismo nestes algoritmos, não é? Entre outros autores. Poderá ser inaugurada a era da ditadura da inteligência artificial, ou seja, estamos a ficar demasiado robotizados, que aprofundará a superabundância de preconceitos sociais, não é? Tudo isto que eu estive a falar antes, religiosos, políticos e raciais, que atravessou o grosso da história da humanidade, não é? A vida toda nós convivemos, ou seja, mesmo com este progresso da humanidade, nós continuamos a viver, de facto, situações de racismo, religioso, destas situações, não é? Existem diversas definições de inteligência artificial, mas McCarthy é considerado o pai ou um dos pais da inteligência artificial e define-a como sendo uma ciência computacional que propende a entender a inteligência humana. Reside uma preocupação neste sentido, e depois já vou passar à parte dos drones. Reside uma preocupação neste sentido que é a seguinte: quid iuris, se as decisões automatizadas tomadas pela inteligência artificial estiverem na gênese da prática de um crime no contexto empresarial. Quid iuris, isto é uma questão, não é certo? Quem deverá ser jurídico ou penalmente responsabilizado? A máquina ou o programador humano? Também é uma questão que está a ser levantada. A pessoa coletiva arguida ou entidade equiparada também poderá ser responsabilizada, não é, por estes crimes? Uma possível resposta carece de uma digressão ao cerne da moral, do conceito de moral, de Kant, que se traduz na assunção segundo a qual o ser humano ou artificial deve tomar as decisões certas pelas razões certas, mas não só. A resposta cabal às questões acima colocadas carece de ser enquadrada na capacidade da máquina de agir ética e moralmente, unida quer do senso comum, quer do bom senso, que são duas definições diferentes. Conclusões, relativamente só a esta parte. No estado atual, a inteligência artificial não é capaz de ter livre arbítrio, nem de capacidade de ação jurídica ou penalmente relevante. A inteligência artificial não pode ser jurídica ou penalmente responsabilizada pela prática de crimes no círculo funcional da responsabilidade penal das pessoas coletivas e entidades equiparadas. Existe até um nome em inglês, AI crimes, ou seja, já se estão a atribuir a estes crimes os crimes da inteligência artificial. Então, a inteligência artificial, se não for cuidadosa, regulada e musculadamente restringida, debilitará o lastro da humanidade dos últimos séculos da humanidade. Peço desculpa a redundância. Então, retomando aqui, ou seja, já temos aqui uma pequena noção do que é a inteligência artificial, e não sendo os drones considerados como uma verdadeira inteligência artificial, gostaria de estabelecer, em primeiro lugar, trazer aqui à colação, não é? Quem inventou o primeiro drone? O conceito de drone, em primeiro lugar, nós conhecemos este nome, certo? Drone. Evoluiu ao longo do tempo e a sua invenção não pode ser atribuída a uma única pessoa a um momento específico. No entanto, se olharmos para a história dos veículos aéreos não tripulados, isto sim é chamado drone, porque drone é uma palavra inglesa e nós aqui deveríamos utilizar a palavra VANT, V-A-N-T, certo? Nós utilizamos drone, inglês, mas deveríamos utilizar digamos, esta definição. Veículos aéreos não tripulados, que encontraram várias fases de desenvolvimento. As primeiras tentativas iniciaram no século XX. Depois, criou-se um drone, digamos assim, chamado Radioplane OK-2, em 1939, frequentemente considerado como o primeiro drone verdadeiro ou VANT, como queiramos chamar. Em termos de produção de massa, foi inventado por Reginald Denny, um ator britânico que se mudou para Hollywood e depois se tornou um pioneiro na aviação. Denny acreditava que os drones, ou os VANTs, poderiam ser usados como alvos de treino para artilheiros antiaéreos. Este radioplane, com este nome complicado, OK-2, em 1939, tornou-se o primeiro drone a ser produzido em massa. Depois temos os drones modernos, da época de 80 e 90, temos os drones comerciais e recreativos no século XXI. Portanto, a invenção do drone é resultado de contribuições de várias pessoas e organizações ao longo do último século. A quarta revolução industrial, também reconhecida como a Revolução 4.0, promete aumentar a eficácia produtiva da empresa, reduzir os custos, melhorar a qualidade dos produtos e serviços, criar oportunidades de negócio, criar um impacto nos diversos setores da economia, tais como a manufatura, a agricultura, o transporte, a saúde, entre outros. Existe uma lei que estabelece um regime jurídico para o reconhecimento da operação dos drones em Portugal, que é a Lei nº 109/2019, de 9 de setembro, se é que já não foi alterada, pelo menos esta informação que eu tenho. Ao abrigo desta lei, é estabelecida uma obrigatoriedade de inscrição do drone no Registro Nacional das Aeronaves Civis Não Tripuladas. Depois temos um regime jurídico dos sistemas de aeronaves civis não tripuladas remotamente, através de um decreto-lei, também com um nome aqui em inglês. Os operadores dos drones têm de registar os seus equipamentos e obter um certificado de operador. Eles têm que fazer um curso. O registro tem como objetivo criar um sistema de identificação de drones, facilitando a sua rastreabilidade. A lei estabelece também as condições de operação dos drones. A regulação da tutela jurisdicional efetiva, a regulação e a tutela jurisdicional efetiva são especialmente relevantes no que se refere à proteção da privacidade e segurança pública, pois a utilização inadequada dos drones pode representar violações dos direitos individuais, bem como riscos à segurança. São estabelecidos limites e regras que garantem a segurança e a proteção dos direitos das pessoas envolvidas. No âmbito europeu, a União Europeia estabeleceu diversas diretivas e regulamentos relativamente ao tema que eu trago aqui, nos drones e meio ambiente, e foram estabelecidas algumas diretivas também sobre que regulam a proteção do meio ambiente. São as diretivas Habitats, é assim, são conhecidas como tais. Estabelecem as medidas de conservação da fauna e da flora e dos seus habitats. A União Europeia adotou o princípio da precaução, que determina quais são as medidas de proteção do meio ambiente que devem ser tomadas, mesmo quando existe incerteza científica absoluta sobre determinados riscos envolvidos. Em Portugal, também existem leis e regulamentos que estabelecem normas de proteção ambiental. Atualmente, os drones têm despertado interesse e se tornado uma poderosa ferramenta de investigação penal em diversas partes do mundo, inclusivamente Portugal e na Europa. Eu tenho conhecimento da utilização de drones através de uma pessoa próxima a mim, que é engenheiro florestal, e eu coloquei-lhe realmente esta questão antes até de vir de estar aqui presente neste simpósio. E eu perguntei, mas é realmente verdade que os drones conseguem chegar a determinados sítios e obter registros perfeitos e sobre um incêndio florestal, não é? E sim, têm sido utilizados, foram utilizados este verão, quando houve quando começaram a arder os típicos fogos de verão, não é? Aqui em Portugal e com certeza noutros países. E ele disse, sim, isso ajuda-nos bastante, porque os drones conseguem chegar a sítios onde o ser humano não consegue chegar. Têm uma imagem perfeita, captam imagens e são realmente um instrumento ótimo para a proteção do meio ambiente. E obviamente, o combate a muitos destes crimes florestais em termos de fogos, por exemplo. Ainda há outros, mas no estrangeiro. No entanto, o uso destes drones na investigação penal, voltamos à investigação penal, no fundo é um crime pode ser considerado um crime ambiental, não é? Em termos de fogo, mas levanta questões legais e éticas que existem uma análise aprofundada das bases legais em vigor em Portugal e na Europa. É fundamental garantir que o uso dos drones não viola os direitos fundamentais dos cidadãos, equilibrando a necessidade de segurança com a proteção da privacidade. A utilidade pode reverter a favor do objeto do processo, mas também na sua vertente subjetiva. Pode servir para encontrar os delinquentes numa situação de flagrante delito, ou a outras pessoas que, sem estarem a cometer o delito, estão a ser procurados como consequência de dados existentes na investigação em si mesma. Do ponto de vista ético, é preciso ponderar sobre a invasão da privacidade que o uso de drones pode representar. Já aconteceu em variedíssimas situações. Um colega meu tinha um drone, estava eu a viver em Espanha há cerca de uns 5 anos atrás, e o meu colega tinha um drone, quando eles começaram a surgir, mais ou menos, não é? E ele disse, eu comecei a manipular o drone, acho que é assim esta linguagem que se utiliza, comecei a comandar o drone e foi filmar o Escorial, não sei se alguém conhece o Escorial em Madrid. Eu estava em Barajas, ou seja, nós vivíamos à beira do aeroporto, e ele decidiu comandar o drone até ao Escorial, que é uma distância, foi verdade, isto é verdadeiro, mas eu sei isto há uns anos sem ainda ter esmiuçado, digamos, esta questão. E o meu colega disse, fui logo contactado pela polícia, porque o drone entrou no Escorial. O Escorial é assim uma espécie de tem assim como é que eu ia dizer, é uma igreja, é um mosteiro, não é? E depois no meio tem um pátio, mas só acede àquele pátio quem passar a porta, não é? Quem tiver as chaves ou quem pagar um bilhete, não faço ideia. Mas ele foi com o drone e começou a filmar aquele pátio e tudo, o Escorial, o Escorial é o Escorial, não é? E foi curioso que ele foi contactado imediatamente pela polícia, porque detectaram detectaram que o drone era dele, chegaram à morada dele, ao nome dele, a todos os dados dele, e perguntaram o que é que ele estava a fazer. Eu só estou a fazer um passeio, mas meu senhor, está a fazer um passeio, mas está a violar aqui está a entrar aqui no mosteiro. Isto não pode ser, isto é crime, tenha cuidado. Mas eu só queria, eles assim, não queremos saber, eu só queria passear, mas isto não é um local para se andar a filmar, fazer filmagens privadas, não é? Pronto, então foi curioso esse caso relativamente aos drones, e realmente aqui, hoje em dia, passados estes anos todos, não é? Graças a muito trabalho também, eu acho, já há alguma legislação neste sentido. O uso indiscriminado de drones na segurança pública pode gerar percepção de vigilância excessiva e levar a um clima de desconfiança entre a população e as autoridades. Também há outra questão interessante aqui, que se estabelece em relação à inteligência artificial. Ou seja, temos um robô, certo? Eu programo um robô, a Alexa. Fui eu que programei a Alexa, estou super contente, tenho muito dinheiro no meu bolso, mas a Alexa começa-se a portar mal. A responsabilidade é de quem? Do programador, da Alexa, ou seja, isto ainda está um bocadinho por decifrar. O que é certo é que muitos programadores que inventaram estou a falar nos drones, podemos incluir aqui muitas situações de inteligência artificial, os robozinhos que vão levar não é, a comida digamos ao hotel, não é? Uma pessoa pede um chá e chega lá o drone, e o drone também vai fazer uma limpeza lá fora, faz limpezas no hotel, ou seja, o drone é multifacetado. E fala e diz obrigada, tem aqui a sua tal. Mas é curioso é que nós podemos colocar esta questão. Então, mas afinal, quem é que vai ser responsabilizado no meio disto tudo, não é? Eu apenas criei a Alexa. E o que é que está a acontecer? Isto está a provocar um atraso tecnológico. Porquê? Porque os programadores digamos assim, das inteligências artificiais, se me permitem dizer desta forma, os programadores, os criadores, o que queiramos chamar, já estão a ter um certo receio. Mas isto está a criar um atraso tecnológico, porque eles têm receio de virem a ser penalmente não é, responsabilizados, porque a Alexa não estava bem, os algoritmos não estavam bem acertados, e a Alexa, de um momento para o outro, em vez de dizer olá, boa tarde, começou a insultar toda a gente. Eu costumo dar um exemplo que até me riu bastante, mas a Alexa, eu falo na Alexa, que eu imagino a Alexa, uma boneca bonitinha, dizer olá, boa tarde, com não sei o quê. Imaginem a Alexa cruzarem os cabos, como se diz em Espanha, se cruzam os cables, os cabos começam a ficar cruzados e ela agarra-me e deita-me a mão ao pescoço. Como é? Eu rio-me agora, não posso rir, mas levo uma chapada da Alexa com uma faca. Por exemplo, ou até o próprio robozinho, coitadinho, mas eu não sei se ele tinha braços. Se ele tem os braços, pegar numa faquinha, eu peço uns talheres e ele, muito boa tarde, Luísa, pomba, aqui tem. Quem é que é quem é que é responsabilizado nestes casos? Isso é extremamente importante, mas há muita divergência doutrinal, há muita gente, uns dizem que sim, outros dizem que não, e há aqui muita confusão. Pronto, mas passando à frente desta parte ética, digamos assim, também entramos aqui nos drones. A história dos drones foi realmente interessante, trouxe aqui alguma... Fiquei curiosa sobre isto, sobre esta questão, porque surgiu um drone precisamente durante uma guerra, durante a Segunda Guerra Mundial. Como é que alguém naquela época foi pensar em criar um drone, certo? E que hoje em dia é tão útil, mas não eram drones assim. Eu vi fotografias, não decidi não trazer, era um senhor sentado numa cadeira, toda a gente, qualquer pessoa pode ver, era um drone gigante. Aquilo era, não sei como é que ele conseguiu produzir aquilo, mas o que é certo é que ele produziu. Entretanto, o futuro dos drones é realmente um tópico vasto e emocionante, que promete trazer transformações significativas, obviamente, novas maneiras de transportar mercadorias e pessoas, a potencialização da agricultura inteligente, contribuição para o meio ambiente, porque eu vim aqui falar sobre o meio ambiente e a saúde. Os drones têm também um papel promissor a desempenhar na sociedade global. Em última análise, a história dos drones representa um reflexo da nossa era tecnológica, encapsulando tanto o potencial transformador quanto as complexidades inerentes ao avanço rápido da tecnologia, sem nunca esquecermos que eu vou programar uma Alexa, ou uma Luísa, ou uma Maria, quem me dera é que programa assim uma Luísa, não é, de inteligência artificial, um dia quem sabe, mas que fosse uma Luísa perfeita, não é? Sem erros, sem ficar, sem deitar a mão a dar um estalo a ninguém, quer dizer, a Alexa com os algoritmos perfeitos, não é? Mas, e aqui, os programadores têm coitados, entre aspas, têm uma função um bocado ingrata, porque não querem evoluir, não há um avanço tecnológico por causa deste receio. Com os drones acontecerá o mesmo. O estudo dos drones é, portanto, não apenas um exemplo de uma tecnologia específica, mas uma janela para o nosso próprio tempo e para as possibilidades e dilemas que ela apresenta. Existem diversos estudos de caso, não vou entrar neles, já falei demais, não é até às 9:10, mas quase, não é? Falta um bocadinho. Ainda tenho 20 minutos, não é, Dr. João? Dr. Fábio, se o Dr. Fábio, Presidente Chairman, posso falar mais 20 minutos, 1h. Exatamente. Eu estou aqui a defender o meu direito de ser mulher, não é? É um direito que me assiste. Eu podia até querer não ser, não é? E havia que respeitar isso. Casava comigo, um ao outro foi. Lembram-se do Miguel Esteves Cardoso? Não casava com ninguém. Bom, então, vamos lá falar aqui seriamente sobre isto. Então, os estudos de caso de sucesso. Estudos de caso de sucesso, temos o resgate das montanhas dos Himalaias, por exemplo, o resgate de pessoas, estamos a falar aqui do resgate de pessoas, temos a vigilância de culturas no Iowa, nos Estados Unidos, temos a entrega de medicamentos no Ruanda através dos drones, não só de pacotes de leite nas prisões, como já aconteceu aqui em Portugal, um drone dava um pacotinho de leite, se é que eu não estou errada, e acho que o pacote de leite caiu no sítio onde não devia, certo? E pronto, explotou-se logo ali um problema. Pronto, fizeram melhor estes, pronto, pelo menos eram medicamentos no Ruanda, não era um pacote de leite. A inspeção de infraestruturas no Reino Unido, a proteção de espécies ameaçadas na Austrália, o combate aos incêndios na Califórnia, bem como em Portugal, como disse o Gide Fonte Segura, porque é o presidente, agora não sei bem das siglas, mas pronto, é o presidente que tem a ver com as florestas e esse senhor, que até faz parte da minha família, é cunhado, o meu cunhado, disse-me que exatamente isso, sim, que os drones estão a ser utilizados e que são super úteis neste sentido. Estes estudos de caso destacam o potencial dos drones numa variedade de aplicações práticas e demonstram como a tecnologia dos drones está a tornar-se uma ferramenta essencial em diferentes setores, oferecendo soluções que não são apenas eficientes e económicas, mas muitas vezes vitais. Obviamente que esta é uma área de inovação contínua, com potencial ainda inexplorado e promete continuar a surpreender e a beneficiar a sociedade nas últimas décadas. Esta situação obviamente terá grandes implicações para a história. Suponhamos que num futuro existirão equipas de drones com inteligência artificial capazes de construir edifícios, entregar pacotes nas cidades e até responder a emergências. Tudo sem que os humanos os controlem, porque até à data nós temos um comandozinho que controlamos os drones, mas num futuro se calhar eles até vão sozinhos. E para terminar, tenho aqui gostava de partilhar aqui uma coisa, se eu soubesse partilhar aqui. Exatamente. Já estive... Oi, apaguei a sessão. Agora vou partilhar os 20 minutos que me faltam em PowerPoints. Mr. Chairman, Sr. Presidente, posso? Estou autorizado a dar-me um aval positivo. Senhor Professor Doutor, may I take another 20 minutes to make a PowerPoint? Yeah?
Yes.
Do you mind?
Yes.
Thank you very much. I'm joking.
I know.
Ai, como é que é isto?
But you have it.
E agora onde está? Não, mas partilhar o quê? Ah, não, mas não está aqui. Oh. Não sei onde estava, mas não está aqui a minha folhinha.
É preciso abrir o documento.
Onde é que ela está?
Na área de trabalho. Posso? Para considerar no ambiente de trabalho.
É que eu nem vou dizer nada. Ainda bem que eu não tenho a Alexa em casa, aqueles que batem as palmas. Alexa, escolhe uma música. Não é? Eu digo sempre Alexa, mas acho que eles até já é Marias. Não tem nada disso. Eu nem sei mexer com isso, como é que eu vou ter a Alexa? I cannot take care of this. How should I take care about hello, can you put me a slow music or whatever, or a Brazilian music to dance? You know, somebody take home, choose me a restaurant, please. Tá aí, doutor. Okay, many thanks. Thank you.
Now it's working.
Choose me a great
Hã?
lawyer. Choose me a great lawyer.
Está a ver aqui, pronto, agora aqui, eu não sei como é que vou fazer isto, mas não sei se conseguem perceber aí.
Já.
Pronto, eu arranjei este nome
Conseguem ver?
engraçado. Eu não sei se em português conseguem perceber o que é uma andorinha. Acho eu, que toda a gente sabe o que é. Em brasileiro sabe, né? Não é preciso não, que a minha voz é muito grossa, muito alta. Uma andorinha não faz o verão. E eu decidi pôr este, digamos, por este título aqui para terminar, porque obviamente não é com um caso que nós vamos determinar toda uma era, digamos assim, e todo um estudo sobre os drones, inteligência artificial e o que for. Então eu escolhi este caso, não sei se está, I don't know if it's well translated. Do you understand? For me it was quite strange to see this here. One swallow does not make a summer. But for us it's like como é que se diz andorinha?
Yes, I know.
Yeah, they go together
Yeah.
when it's spring. So,
But that is not make a
but it's not a swallow.
in our
It's
country,
strange.
it's similar.
Yeah. So this drone, there we go. Este drone que encontramos aqui já até foram as minhas estudantes, são ali sentadas, devo dizer. Minhas estudantes, minhas alunas e amigas, companheiras de Lusófona, que me mostraram-me esta notícia, eu achei uma notícia curiosa. O drone foi lançado a partir da casa de uma família de um dos prisioneiros, transportou o telemóvel do recluso para a prisão para o estabelecimento prisional. O Ministério Público pediu autorização ao juiz para fazer uma busca à casa do prisioneiro, não é? Do suspeito, por ter pilotado o drone que entrou numa cadeia, que entrou na cadeia, não é? E o juiz recusou. Por isso, já há aqui uma divergência, não é? Este evento desencadeou um debate entre o Ministério Público e um juiz de instrução criminal sobre um drone, sobre se um drone pode ser considerado uma extensão do corpo humano. O Ministério Público acredita que sim, enquanto o juiz discorda. Foram apanhados entre tantos crimes, não é? Entre tantas situações que acontecem, foram apanhados 79 telemóveis na prisão de Passos de Ferreira e outro material tecnológico. Existem drones a entregar telemóveis nos estabelecimentos prisionais e as autoridades têm implementado várias medidas para combater a entrada de drones nas prisões. I translate this in English, like in here, as you can see, because this was here in Portugal.
Yeah.
There was a drone, I will say in English, it was going to the prison in Portugal. Somebody was controlling. Medidas a serem implementadas, a criação de zonas de exclusão aérea, o uso de tecnologia para detectar os drones, também já foram feitas estas, já se trabalhou um bocadinho neste sentido, o uso de drones para segurança e os relatórios sobre contrabando, porque também há muito contrabando através de drones. Pronto, enfim, os drones estão a ser manipulados, estão a ser bem usados no combate digamos, a fogos florestais e tudo mais, mas também estão a ser usados para outras situações menos positivas, certo? It's for you to read.
It's Ukraine drones are a weapon. It's a very
Yeah.
dangerous weapon.
Yeah.
Yeah. For drones, you must bump over here and go over the street.
Okay.
It's
They
precision weapon for that. Yeah. It's very
as you can
dangerous.
see, for us, is a kind of a support for something, and is a kind of support as well to take
It's a new
drugs.
weapon. It's a new weapon.
So, e com isto termino, já comecei a ver que a plateia está cheia de fome, já estão a chegar Não, são 8 menos 20. Eu tenho uma hora. Ainda tenho uma hora, meu Deus. Muito obrigada pela vossa atenção, espero que tenham gostado. Da próxima será melhor.
So, by the prerogatives of table president, with authorization of my friend Fábio Veiga,
I'm going to make myself two questions when you are thinking about the questions that you are want to make us. So one for Luisa and one for Igor, based in this presentation that congratulations, Luisa Brandão Barrios have done so well at home. So ladies first, Igor, if you allow me. Luisa, in the future, we are known that electric cars are going to be on the streets everywhere. But the most tested ones are going to be right now drones. Will you or will you not pick up a big drone with me for going to the cinema with no driver? A big one for, not for you that are slim and elegant, but for me is going to pick up here in Oporto. Yes, it's a taxi, it's a Uber. It's a drone Uber with artificial intelligence with a central ordinator centralizing everything, and you pay by your phone. I only pay in cash, so no paying for me. I will pay the dinner or the movie, or it's not for me. It's not for me, and I go to you with you to the cinema. No, I came here to Lusófona, wait for you. You call up this drone, kind of a cab, and we are going to Coimbra on it without nobody driving. Should you not go on this drone? And why? No. Okay. Should I go with you in this drone? Okay.
Yes, I'll take this cab.
And if we fall down, who is going to pay the civil responsibility? No, who is going to pay the civil responsibility of the accident? It will be the programmer, it will be the mechanics, engine responsible. It will be the branding of this cab. I don't know, it will be Mercedes or it will be, I don't know, it will be Nokia or whatever, Samsung cab. Who is going to pay? They are in German, they are in India, perhaps they are in China. It's a Chinese kind of drone. That
if they see somebody crossing the street, they stop. But I think it was not so far away that the cars, or somehow the car didn't stop and kill somebody or whatever.
Who's going to pay? Is the client?
In my opinion.
The programmer, the one that it's in America.
Why? Because it was putting the algorithms
wrong. No, we mean. Oh no.
Okay, I was reading things and I was making a small course regarding.
No, in English, that's good English.
Eu fiz inteligência artificial e colocar exatamente essa questão. Ou seja, quem é que é responsabilizado? Vamos ler um pouquinho sobre isto, não é? Podemos realmente há muitos livros sobre isto, mas já vos disse, tenho aqui imensas pessoas já falarem sobre este tema. Eu gosto especialmente dos livros do Dr. Hugo Luz, mas obviamente que há outros. Yeah, he talks a lot about this and yeah. Não, a mim não me interessa tão bem. Deixa.
In the owner side. And the second is in the technology. I think so. It's a civilist discussion. Yeah, but
to have another pick if you want me, if you let me. And the question will be going for Igor Dominic, because you are the legal judge in the Supreme Court. And in what sentence do you rule in this case that she's presented? Not this one of no, the one she talks in Portuguese in the end of her presentation, in a criminal fellow that is already in prison, has used a drone that it's in his home with a device they get him, for bringing him back a mobile phone for committing crimes of drugs or talking outside with this squad of criminals to perpetrating more crimes. Who should be punished? The guy that made the drone, the guy that programmed the drone, the prisoner that using the drone against the prison. I don't know.
Could even know that. You know, it's the penal law is penal for person who do the crime. So if you have a drone and you check it for, cases to be crimes, so you have to responsible for that.
So the owner of the drone, you
that person who started him here. It could be the owner, but it's not.
The one that's using the device.
Yes. It's committed the crime, but the civil responsibility could be different.
Okay, so you.
Because that person knows that he made a crime for that. Yes.
So
Yeah.
You agree with her when she says that the drone is kind of an extension of the
Human body.
The drone is, I think, is only drone is it's not a person.
So
Drone is only.
you cannot responsibilize the drone, only the users of or the owners of.
It's instrument for person, and
It's
person
kind of
do it.
like a gun.
Yeah.
Gun for itself don't commit crimes.
Yes, it's possible.
Sometimes they said in penal law also that guns don't kill people, bullets do.
Bullets,
But
yeah.
really, someone is needed to pull the trigger, and that will be the penal charge.
It's like a knife, you put the knife in another person, so you made a crime. And even when I get a drone, and it's
There's no responsibility.
yes, I think so.
It's not going alone, and the drone, yes. It's
It's
flying.
like a car,
Elections, walking.
when you're driving a
It's
car,
like-
and after that you put it in another
But the
person.
car is with algorithm. It's prepared.
Now it's car with algorithm. It's for Tesla or something. It's
You have cameras.
yes, they
And the
drive alone.
connected?
Yeah.
Aproveitando aqui, eu não
I
sei
think it's a new problem for
Yeah.
civilization to what kind of law to decide. Yes.
Exactly, regulation for
For
this.
se estes magníficos são secretos. Dizer a todos os alunos presentes para não se irem embora, para além de terem que tirar uma fotografia,
Só às
para
nove.
provar que estiveram aqui, vai ser feita uma descarga de presença do professor Fábio Veiga, de quem esteve cá, para depois montar para a presença da aula. Eu não sei se da doutora Luísa.
Não, na minha não. Se não fosse na minha,
Ela tem boa memória, portanto,
eu já sei quem
ela
é.
já vos fixou.
É um.
Então, se não houver mais nenhuma pergunta da sala, o Mário Barata já sabe onde é o jantar, portanto não há qualquer problema, está tudo respondido. Agradeço a presença de todos e todas. Agradeço a presença de todos e todas aqui nesta sala presencial, na sala de atos da Universidade Lusófona do Porto e online através desta magnífica internet por todo o mundo, a presença neste International Symposium of Legal Research. For you, my dear friends, this is a house for coming back whenever and wherever you want. Also for you, Thomas, and for other fellow men or nothing. Coimbra is also expecting for you, and I hope we can see you in another forum, presentially or online. Thank you very much, and a round of applause for you all. Então convidava toda a gente aqui a fazer a fotografia da praxe e a seguir os eventos da IBEROJUR e aqui da Universidade.